Very good. Mr. Smith and Mr. Coors, I see you are both in our virtual courtroom. Mr. Coors, we are ready when you are. And you need to take the microphone off mute, Mr. Coors.
Sorry about that. Good morning, Your Honors.
Good morning.
Please the court. My name is Dennis Coors, and I represent the plaintiff appellant Robert Hicks in this matter. With court permission, I'd like to reserve 5 minutes of my time for rebuttal.
Very good.
This case presents a petition for certiorari seeking review of a final summary judgment entered by the County Court of Hillsborough County and the affirmance of that judgment by the 6th Judicial Circuit Court sitting in its appellate capacity with a well-reasoned and written dissent by Judge Rice. At its heart, this is a simple breach of contract case. My client, Robert Hicks, is now a retired Florida lawyer and an avid art collector. Mr. Hicks became acquainted with and developed a professional relationship with Mr. James Boggs. Mr. Boggs was a local artist who achieved significant worldwide acclaim and notoriety for his artistic renderings of currency, which became known as Boggs Bills or Bills by Boggs. Believing that Mr. Boggs' art was unique and had a potential for future appreciation, in 1999, Mr. Hicks and Mr. Boggs engaged in a series of discussions during which Mr. Hicks agreed to commission Mr. Boggs to create a unique set of Boggs bills to be known as the Justice Series, which would feature the justices of the U.S. Supreme Court. These bills would not only be unique, but offer a special meaning to an artistic lawyer. Based upon their discussions, the gallery that represented Mr. Boggs prepared a memorandum proposal describing the art commission, setting forth the price of the art, together with a significant detail concerning the product to be delivered. Based upon the memorandum proposal, Mr. Hicks prepared an agreement, which included all the terms needed to form a valid contract. The agreement contained the price, the amount of the deposit to be paid, the terms of the final payment, the refund amount to be paid in case of dissatisfaction with the work. The contract identified the deliverables to be created with great specificity, that being 6 separate Boggs bills or bills by Boggs to be in specified denominations. The memorandum specified the media to be used, the type of paper, the color of the ink to be used, and even the dimensions of the deliverables. They agreed to the timing of delivery, that being at some unspecified future date, at a timing that both parties knowingly were satisfied with. Mr. Hicks paid the deposit of $6,000 to the art gallery. That payment was acknowledged by the gallery and its receipt. That gallery represented Mr. Boggs, a representation that Mr. Boggs acknowledged with his signature, along with the signatures of Mr. Hicks and the gallery representative. Mr. Hicks waited patiently for Mr. Boggs to perform. He made an investment. He was willing to see what it might harvest. After all, the object of the investment had to be created. It comes from the mind. It's not something that you simply go into the room next door and press it out of some material sitting on the workbench. It requires a creative flow of juice, something that I certainly have no ability for. Mr. Hicks waited patiently. He waited 18 years. 18 years went by, and he waited until Mr. Boggs unexpectedly died at a relatively young age. It was at that point that it became clear that Mr. Boggs would not be performing. Mr. Boggs had suffered the ultimate breach of contract. Upon learning of Mr. Boggs' passing, Mr. Hicks timely filed a claim in Mr. Boggs' probate proceedings seeking recovery of the sum of $6,000. Not seeking some unreasonable profit, not something that, an expectation, rather simply seeking recovery of the money he paid that he had not received anything for. The Boggs estate objected to the claim, necessitating the filing of the actions that bring us here today. Pursuant to section 733-705, Mr. Hicks timely filed a verified, simple 3-count complaint alleging breach of contract, return of deposit.
Mr. Coors, let me ask, as a hypothetical matter, if Mr. Hicks and the artist were both very young men when the contract was entered into, and 30 years go by, 40 years go by, and nothing happens, but the artist has a car accident and dies, is it your position that the statute of limitations has not begun to run because your client never demanded performance? Or is it your position that it's up to a jury to determine what's a reasonable time period? So is there a line to be drawn anywhere in there?
As to Mr. Hicks, there is no line, Your Honor. Mr. Hicks paid his money and waited. He had done everything he had to do to perform. And if he was satisfied waiting for 30 years to see whether or not Mr. Boggs performed, that was his right to do. His prejudice is that of waiting. Mr. Boggs has no prejudice. He's already received his money. He has nothing to complain about.
He's received a portion of his money, correct?
He's received a portion. He's been paid half of his money, with the other half to be paid to him upon delivery of the goods.
So I guess the answer to my question is no time frame or no statute of limitations begins to run until such time as your client, demands performance, and then Mr. Hicks refuses or fails to perform? Until
either Mr. Hicks demands performance, which I'm not sure actually would start it, since the contract provides Mr. Boggs the right to deliver at an unspecified period of time. But certainly at such time as Mr. Boggs would have abandoned the project, perhaps at that point in time, had he affirmatively said, I'm not going to do this, then perhaps at that point in time, the statute of limitations would commence to run.
So based on the wording of the contract itself, then, if your client had demanded performance, let's say after 10 years or 15 years, and Mr. Boggs says, nope, I'm not ready to perform yet. You just got to sit tight. I don't know when I'm going to get to it, but I'll get to it sometime. Would your client have been able to sue on the contract, or your client would not be able to sue because the contract says some unspecified date and Mr. Boggs was able to rely on that?
I believe, in fact, Mr. Boggs would have the right to rely upon that, to say that the contract says unspecified date. That's a term that they bargained for and agreed to. And so I believe Mr. Hicks was stuck with that term. And Mr. Boggs had the right to perform at whatever point in time he deemed it appropriate and to receive the balance of his funds. Could there come a point where perhaps it becomes unreasonable? Well, that is some of the case law that's been proposed. But in that case, it isn't for Mr. Boggs to determine what the unreasonable time is. It would be for Mr. Hicks to determine when the time becomes unreasonable. Mr. Boggs has no basis for claiming that we waited too long. He's the one that hasn't performed. He's received his performance. He's the one that's failed to go forward and do something. And of course, that is the opposite side of the Hatcher case that's been cited in the briefs extensively, where an attorney performed services but was waiting for payment. The court said we're going to infer that it's a reasonable time for payment. Well, in this case, payment has already been rendered. And the question is, what is a reasonable time for performance? These fellows negotiated a term, and I believe they're both stuck with it.
Judge Lucas, were you starting to ask a question? I just noticed your microphone is off.
No.
Okay, I thought you were.
Your Honor, you have further questions? Shall I continue, Your Honor?
If you can continue, or if you're done, we'll hear from.
Okay. I'll continue, Your Honor. So we filed a 3-count complaint seeking breach of contract, unjust enrichment, essentially, and a specific performance. The specific performance count was always a simple hope and prayer that perhaps Mr. Boggs had produced some or all of the Justice Series Boggs and just hadn't told us about them or delivered them as of that point. It always seemed like a long shot, but certainly stranger things have occurred. And in the spirit of if you don't ask, the answer is no, we thought we'd ask. So that's why that count is in there. We concede that the likelihood is that's not going to go anywhere. However, I don't concede that it's barred by the statute of limitations, in that it's simply another action for potentially obtaining the goods that were promised to be delivered. The estate responded with 4 affirmative defenses. They attacked the validity of the contract. They asserted that the complaint did not demonstrate that we had made payment in accordance with the contract. They asserted that there was a possibility of performance as a result of Mr. Boggs passing, and asserted that the case was barred by the statute of limitations, section 95.11. After some limited discovery by the plaintiff, not by the defendant filed a motion for summary judgment. The motion for summary judgment was unsupported by any affidavits, unsupported by any depositions, unsupported by any sworn testimony of any kind. The only thing it had was some answers to the plaintiffs, to our interrogatories, was the only quasi-sworn testimony in terms of the record before the court. In addition to having filed a verified complaint, the plaintiff filed a timely affidavit in opposition to motion for summary judgment, which, among other things, asserted a reasonable basis and explanation for Mr. Hicks remaining patient rather than seeking performance. It also provided a factual background of the formation of the contract, relationships of the parties, and further authenticated the payment of the 50% deposit, including a copy of the canceled deposit check, front and back. At the hearing on the motion for summary judgment before Judge Fernandez, the estate argued that the lack of a definitive delivery date rendered the contract unenforceable, and because 18 years had passed since the contract was signed, the contract was barred by the statute of limitations. In response to the plaintiff's inquiry of the court as to the basis for determining the date on which the statute had run, the defendant argued that it was up to the court to determine what a reasonable time for Mr. Hicks to seek enforcement was, and that such determination was a matter of law and not a question of fact. It was argued that it did not matter when or if the breach occurred, rather it is simply a matter of being too long. Hicks argued that neither he or Boggs had asserted any breach of the contract, and the record does not reflect any assertion of any kind that Mr. Boggs or Mr. Hicks engaged in any kind of action that would be deemed a breach prior to Mr. Boggs' death. And that at the time of his death, 5 years had not passed from any alleged breach, and at the time of the filing of the 733 complaint, there had not been the passage of 5 years. So in our view, the statute of limitations would have begun to run at Mr. Boggs' death, and that we had 5 years from that date, and we were well within that 5-year period to bring the action. County Court granted the motion for summary judgment, citing simply that all 3 counts were barred by section 95.112. No analysis or factual background was included in the final judgment. Hicks sought rehearing of the final judgment. By the time Hicks' motion for rehearing was set for hearing, Judge Fernandez had retired, and Judge Manning took over that division and presided over the motion for rehearing. Argument was made at the motion for rehearing that the contract is valid and not barred by the statute of limitations. Judge Manning denied the rehearing and affirmed the summary judgment without further comment or support. The appeals that bring us here today and therefore ensue. In this petition for certiorari, there are 3 primary issues, or perhaps 1 issue with 2 sub-issues. First being whether the county court departed from the essential requirements of law and determined that no genuine issue of material fact existed, which would preclude the entry of a final judgment. Second being whether the county court departed from the essential requirements of law in granting the defendant's motion for summary judgment by determining that there was no formation of a contract. Now, we don't know if that was the basis because the order did not say what the basis was, but given the status of the pleadings, we can only determine that it was either this or statute of limitations, and since the order kind of references the statute of limitations, we think that was the basis, but the order certainly leaves us wanting as to what was in the mind of the court beyond the statute of limitations. Third being whether the county court departed from the essential requirements of law in granting the defense motion for summary judgment on the basis of the statute of limitations. Each of these issues has been thoroughly briefed through the appeal to the circuit court and now this appeal. Additionally, we have the benefit of a well-reasoned, extremely thorough opinion of Judge Rice in her circuit court dissent. I'd like to adopt with proper credit the opinion of Judge Rice, wherein she provides a legal analysis of the issues that's far better than anything I could possibly do in the next few minutes. In urban slang, I would like to simply say what she said. However, there are a couple of areas that I would like to further discuss.
Mr. Kors, just let me let you know you're at the 5-minute mark. So if you want to reserve your 5 minutes, or you can keep going.
I guess I'll reserve my 5 minutes then. Thank you, Your Honor.
Very good. Thank you very much. Mr. Smith?
Thank you, Your Honors. My name is Eric W. Smith. I represent the Appellees, the estate of JSG Boggs. You were the defendant in the lower court proceeding. Your Honors, respectfully, the cases at bar with this appeal do not represent any new issues for the court. At each stage of the proceeding, at summary judgment, final judgment, motion for rehearing, and the appeal with the 13th Judicial Circuit, no genuine issues of material fact were represented to prevent the entry of summary judgment in favor of the appellees.
I've got a question. I don't know if it's a question of material fact or maybe just a question of clarification. But are you aware of a reported decision where a court adjudicates a violation of a statute of limitation as a matter of law on summary judgment, but never states when the statute of limitation accrual period would commence, which is what appears to have happened here?
That's correct. And I did not. And in this proceeding, the reason being is that there has never been a case where someone had waited 5, 10, 15, almost 20 years. And then for a breach of contract case, when you assert whether statute of limitations apply, and then have a separate set of facts as to whether there was a date of performance or time performance, the contract is silent. The next step is for the court to imply a reasonable time of performance. That's done over and over in foreclosure.
Well, so you didn't find a case that says, yeah, trial court, you don't have to really answer the question definitively when it runs, just as long as you can say definitively whenever it was it ran. How about this? Because I got to tell you, I found the position that that the estate took to be kind of interesting on that notion of reasonable time. Are you aware of a reported decisions where, like here, the reasonable time of performance vein of contract law is being asserted by the party who owes the performance to bar the party to whom the performance is owed from even being able to enforce the contract?
Even in that proceeding, though, with the time period that has passed, and that was a unique set of facts in this case, with it being over 15 years, the court could still, on its own accord, using other cases where you have the inherent authority to imply a reasonable time, took that set of facts and said, look, we have to address the statute of limitations, but given the facts presented in this case, no matter who presented the issue to the court, there was this significant delay of 15 plus years, and now trying to establish that I have a valid contract and I want relief. What is the court to do in that position when observing the 5, 10, 15, 20 plus years that have gone by?
I think what the other side would answer is let the jury decide, because the trial judge in this case took that away.
Very interesting that you mentioned that. May I have a moment to respond to that?
Of course.
So with regard to that issue of a reasonable time being a potential question for the jury, we quoted the Hatcher v. Miller case, a case from the First District Court of Appeal from 1983, where a similar issue was the defendant owed money to a lawyer, the lawyer sued, and on the trial court level, the lawyer said that, well, it was my opinion that I had an indefinite time to pay the attorney, and then on summary judgment when he lost, he says, well, I believe that question about my time to pay should go to the jury. He argued that the rendering summary judgment denied him his right to a trial by jury on the issue of whether money is due now or at some indefinite time in the future. And that appellate court affirmed lower court decisions showing that when no time or an indefinite time is specified in the performance of an act, the law implies that such act will be performed within a reasonable time. And in the cases that were cited not only by the appellant, but also by Judge Rice, those involve particular cases of tort law or negligence or legal malpractice or medical malpractice where the issue of what the victim or defendant should have known, what they did know, the issue of when was notice provided to a claim, all those issues were very specific to the claim of negligence, that it was inappropriate for statute of limitations to apply in those cases.
So here's the thing about that though, because I'm looking at the jury instruction, and I think your argument is half right, that it is incumbent upon the trial court to define what is the appropriate time frame that the jury has to decide when the statute of limitation, what is applicable for the statute of limitations. But when it accrues would be a jury question. That's a classic jury question.
Well, so if the question of when that triggering event happens or when it accrues, and if it is indefinite, and if you're relying on the appellant to say, well, either A, it doesn't apply at all because I don't have a triggering event, or if it does apply, it applies when at the death of the decedent, which is 17, 18 years later, the court then takes that set of facts in the case and says, well, look, I can't figure out what the triggering event is based on what you're saying, but I do know that 18 years is by law unreasonable. I have the inherent authority to state that by law, that amount of time isn't reasonable. If the appellant wants to provide other evidence to avoid summary judgment to state, well, look, this is what the parties agreed to, this is what I stated, here's some parole evidence. That wasn't present in this case. There was an 18-year delay for the appellant to now want to state, I have a valid contract, I want my money. That was determined to be an unreasonable amount of time for the court.
Mr. Smith, I want to explore two different issues. First is the affidavit in opposition to summary judgment in paragraph 5 sets forth something that is somewhat unique, at least in my experience, which is, as is common in the world of art, the date for delivery was to be left to the artist. The discussions between the affiant and Boggs left it clear between the parties that the commissioned series would be delivered at some future date. Why would a trial court be entitled to reject that position or that evidence and apply the analysis that you're suggesting is a normal analysis, that a reasonable period is generally a jury question, but 15, 18, 20 years cannot be reasonable under any circumstance as a matter of law?
I can respond to that in two ways. The first being that given the contract that was attached to the complaint, you had the letter agreement and then the agreement from the agency. And both agreements, they discussed, the type of bills, the art, who's to make the art. But the gallery's contract says a date of 2000. It's dated for 1999, but it says 2000, the date being the year 2000, okay?
But there is no way that you can look at that document and say that is either a start or end date, can you?
Oh, I totally agree. That's my point too. So, but in the letter agreement, it states that, well, we agreed to some indefinite time to perform that standard in the art world. But those two contracts do not say that not share that reference. That is the internal intent or belief of the appellant. That's not what was agreed by both parties. And if you go back to that affidavit and you go back to the last.
Hang on, I need to interrupt you there because I'm not following the argument that you're making on that point. If the contract says essentially that it's an indefinite date for delivery, why does the reference to 2000 in the letter or the document from the gallery suggest something different?
So what I was trying to show there is that the gallery agreement says the year 2000. But in addition to that, the appellant is saying,
hang on, but what does that 2000 mean? What does that refer to?
That's kind of my question too. That's a vague or ambiguous use of a year. Now, if you go back to what the appellant is saying in their argument that, well, it was the belief that it could be formed at some indefinite time, later in the course of proceedings in the evidence, in the affidavit, the appellant states that it was if you go to paragraph 11 of that affidavit, he states that it was the affiant's understanding and belief that the commissioned art would be delivered at any time following the execution of the letter agreement up through the date of the death of James S.G. Boggs, which is not in both agreements.
But is it your position that the year 2000 is starting the statute of limitations?
I am not. I was just showing that it was clear and undisputed that the date of performance or date delivery was ambiguous, vague, silent, or not clear between the parties.
Couldn't the year 2000, the indication of that simply mean, okay, in 2000, the artist is going to start doing whatever an artist does to create a work of art? And not to be too flippant, but we know certain things take artists decades to complete. Clearly, those things are more along the lines of buildings or major, huge projects. So honestly, I'm having trouble understanding why the letter from the gallery changes anything. But let's assume for the sake of argument that it does somehow impact the analysis. What evidence, the burden for summary judgment is on your client. Your client didn't come forth with any specific evidence. We know what the documents are, but the affidavit in opposition basically says, look, the document says what it says, and the artist could perform when he chose to perform. And we don't know if the artist might have started working in some way, sketching things out, and then got distracted by a bigger project. Are those not questions of fact for a jury or a fact finder to determine what was reasonable under the circumstances as to when the statute of limitations began, what act caused it to start running, when it in theory expired, and what's a reasonable time frame? Why would that not be an appropriate jury question?
I don't believe so. For, again, going back to that original contract that you referred to, it states also that the parties, including the gallery, JSG Boggs, and the appellant, believe that they can perform at any time, and even the appellant can give legal services from time to time as they so agree. Now, my issue, though, is that coming back to that affidavit, it says it was the appellant's understanding and belief, solely his understanding and belief, not based on what was argued or was contemplated in the contract, that performance could be at any time up from the date of letter of execution of the agreement, could be 2000, or up until the death of the decedent, which I do not see a mutual agreement between the parties that that was the case. That was solely the intent of the appellant. And even further in his petition, he states—
Hang on. I'm not sure we need to get to what the appellant's intent was. We've got the document that says some unspecified future date. And we have what I think is significant from the appellant, a statement in the affidavit that this type of arrangement is customary in the art world. I don't know if that's customary or not, but there's no evidence disputing that assertion, is there?
So even, number one, that's not a fact in evidence, but even assuming that you infer in the benefit of the non-moving party and say that, well, in general, that is what is the case in the art world. Well, then, even if it was his intent or his belief or thought that, hey, this could be performed from year 2000 all the way up into the death of the decedent, no matter when that is, and now I wait, what is fact and evidence, I wait 18 years to affect this agreement. Now, that is the problem with the case, is that even if that is customary in the art world, waiting 18 years on a contract and saying, here I am.
I got to be honest, counsel, I'm not impressed with that. I mean, you've pounded the number 18 years a number of times. I'm not impressed by that. And here's why. The argument that you are making, and that apparently the county court and the majority of the circuit court have apparently just bought into, is the idea that an indefinite term of contract is just simply not a contract, which isn't necessarily true. I mean, there is no legal impediment to these two men coming to an agreement that says, I will give you $6,000. I will give you another $6,000 upon when you complete these, I guess it was 12 or 14 or something, of these special Supreme Court justice pieces of art. And whenever you do it, you do it. When you finish, I'll give you another $6,000. There's no legal impediment to two people freely agreeing to those terms and conditions. But the county court and the circuit court, the appellate division, took that away and said, no, you can't agree to that. It had to have been within some reasonable time, even though they didn't include anything about a time period in their contract. What legal impediment is there to them just agreeing for it to take however long it takes?
The evidence did not demonstrate that the parties agreed that this was to be performed at any time in the future, unspecified.
You've got a contract that leaves the term open. At best, what you've got at best is an ambiguity. But if you've got an ambiguity, then this should be open for parole evidence, and you should have a jury weigh it and decide it.
I do believe that based on the facts that were presented, and then with the ability that is customary with foreclosure law, if the court, hearing the facts that were presented and demonstrates that, look, if I have the implied or inherent authority to determine whether it was reasonable for this delay to occur, whether I use the defense of statute of limitations or latches, the analysis would be, well, look, it's been 18 years, 20 years. Is that reasonable? Now, if that is a question for the jury, if that was a question that needed to go forward as a fact question, the end result didn't change in this case.
I think, am I hearing you make a tipsy coachman argument that even if the court was wrong to imbue some kind of a term and decree that statute of limitations had run without telling us when it accrued, that latches would save the day? Is that kind of what you're saying?
In some way, but more so that even if this is sent to the lower court to address an opinion as to the statute of limitations, as to the triggering event, as to whether latches applies and all of that, the end result still does not change for the appellant. But the appellant is essentially arguing that.
How do you know? He gets to have a jury decide it.
Well, essentially from, I guess, how the lower courts, the county court and the circuit court took the evidence and heard the evidence that was presented at the lower court level. And at the very first hearing, there was no court reporter present. So the determinations of what was heard based on statute of limitations and on the contract, all the evidence presented.
It's summary judgment, though. I mean, everything has to be taken again, like in a light most favorable to the non-moving party, with all inferences against your client. So fine, but it's summary judgment. Fine, that whatever evidence there was, but whatever there was should have been construed against your client.
And even with that being so, and it was construed against our client.
Right, and they ruled the way they ruled. I get it. I get it. They ruled the way they ruled.
Okay.
The other issue I'd like you to address, Mr. Smith, in your brief, you talk about both parties have addressed the jurisdiction of this court. Some of the cases that you cited to are your more traditional certiorari cases where it is seeking review of something that happened in the trial court. This case comes to us as essentially a second appeal, although it's a certiorari to review the appellate work of the circuit court. The Supreme Court doesn't take cases for review on cert from the District Court of Appeal where there's a PCA issued, but it seems like the case law does support our ability to exercise certiorari jurisdiction based on manifest injustice and whatever else the law requires. So why is this not a case where we should exercise our discretion and accept review when I think the argument on manifest injustice is the plaintiff has been deprived of any opportunity to have a fact finder determine what is a reasonable period for the statute to run under the unique facts of this case?
I think first and foremost, even if this case was to be sent back to the lower court, the first issue would be, given the facts of the case and what was heard, how the judge interprets the law in congruence with the facts of the case. And if the opinion is such that upon review of statute of limitations, I find the event to be this, or based on the notice presented, I find this in place. And based on that, my decision is still that summary judgment to be entered in favor of the appellee. That doesn't necessarily mean that the appellant's right to a jury has been in any way deprived. This might have to go back to a lower court to rehear the issues and form an opinion, but that doesn't just open the door for the appellant to immediately proceed to a jury trial where that hasn't been decided yet. And I guess the issue for the appellant was, I'm not seeing the judge's opinion or the statements to defend entry for summary judgment for the appellee. This isn't necessarily saying that, well, based on what happened here, that he is missing that right to a jury trial. This may, in fact, have to go back to a lower court to decide, well, look, this is what my opinion is.
For purposes of statute of limitations and summary judgment, when the appellant has executed and filed an affidavit saying, essentially, and this is paraphrasing, this type of contract is not unusual in the art world. And there's no counter affidavit. And if there was a counter affidavit, then presumably that might raise an issue of fact for a jury. Here, we don't even have that affidavit. So from your client or on behalf of your client. So why is it not a manifest injustice for the judge to essentially say, despite the plaintiff's affidavit that this is customary in the art world, I am ruling as a matter of law, too long. You cannot have an artist contract that goes for an indefinite period of time be enforceable as long as 10 years, 20 years, 30 years go by.
And respectfully, without speaking for the judges in the case, I would presume that when the issue was presented of the length of time that has passed, and if the court determined that, well, if this was important to this appellant to have this contract or have this artwork in hand, that by waiting for the amount of time that he did, well, then it shouldn't be a miscarriage of justice when, after so many years have passed, and where all of the parties are not present, a person has died that is a relevant and important part of this case, and no one can speak on his behalf except for related members of his family who are the first representatives, and then to address the issue of how long that they're trying to recreate the different views of the parties. Well, was it a miscarriage of justice that the appellant waited that amount of time, but then wants the court to immediately give some recourse either by specific performance, but could not be allowed under statute of limitations, no matter what the triggering event would be? That's a 1 year statute of limitations. That to speak on, I guess, on their behalf, when hearing that evidence and hearing the facts and determining that, well, look, if the point of statute of limitations and latches is to avoid stale claims, well, then it inherently cannot be a miscarriage of justice to the appellant if they chose to wait as long as they did and to now want immediate recourse when half the parties are missing. He's in no way involved the art gallery, but wants us to take his self-serving views on his affidavit as, let's get immediate recourse right now. So,
Mr. Smith, we've come to the end of your time. Unless one of the other judges has a question, we will go back to Mr. Kors for his rebuttal. Thank you.
Thank you, Your Honor. Just very briefly, I want to point out to the court that with this last discussion that latches, promissory estoppel, none of that was pled. We have one single defense of statute of limitations, section 95.11. And as such, any of those sort of defenses were waived when the pleadings were filed without them.
And Mr. Kors, one question. Am I recalling correctly that the dead man statute was not raised?
It was not raised.
And it seems like Mr. Smith's last argument would be more aligned with that statute to try to prevent your client from explaining what happened or what the parties agreed to.
It was not brought up in the court, and it's not a matter of the record. And honestly, Your Honor, I'm not prepared to discuss that at this point.
And the other question I have, and I asked Mr. Smith this. So what is your position as far as you already understand based on the briefing, you don't get a second appeal simply for the sake of a second appeal. So what's the manifest injustice that supports our exercising the extraordinary authority to review what is essentially a per curiam affirmed decision by the circuit court?
Manifest injustice is in fact that the matter was improperly taken from the jury, from the trier of fact, and in the face of overwhelming evidence in the form of affidavits in the file, the court simply removed the finding of facts function of the court from the equation and made a decision apparently based on some completely arbitrary, unsupported basis that we know nothing about. And I consider that to be a manifest injustice. I would also point out to the court that there is in fact a term in this contract. We keep talking about there being a missing term about performance. but in fact, the contract does speak to it. It is not a missing term, not an ambiguous term. It says at an unspecified date in the future. They didn't leave it out. They agreed to it, and that, of course, creates a term that needs to be, then if in fact more is required, then that is a fact-finding matter that would be vetted out in front of a jury or the trier of fact for that matter, because reasonableness is in fact is in the eyes of the trier of fact, applying the law would be the judge. But the question of what is reasonable is a fact question, not one for the court to determine as a matter of law. So in that instance, the court has taken away the fact-finding function of the court and taken to himself that fact-finding without any basis in the record to support it. I think that's all I really need to do, Your Honor. I believe the briefs are complete, and we would ask that the court quash the circuit court opinion and remand for further proceedings.
Very good. Thank you, Mr. Quarters and Mr. Smith. You can exit the virtual courtroom, and the next case is Dial versus Calusa Palms Master Association.